Okay, let's unpack this. The world of AI is sprinting ahead,
Oh,
right?
absolutely.
New models, new applications. Seemingly overnight, it's changing everything from how we work to how we interact with technology.
Definitely.
And trying to keep pace with that innovation while also grasping the complex regulations emerging to govern it, well, that's a monumental task.
It absolutely is.
Got it.
Regulation, by its nature, it tends to lag behind technology, doesn't it?
Yeah.
But with AI, that gap feels particularly wide and dynamic.
Uh-huh.
Navigating something as foundational and broad as the EU AI Act becomes a serious challenge for anyone involved with AI.
Which is exactly what we're diving into today.
Yep.
We've got a really valuable source document, a handbook specifically designed to help businesses navigate the EU AI Act.
Mhm.
Think of this deep dive as us walking through that handbook with you, like guides pointing out the landmarks, the tricky turns, and, the most important things to understand.
Yeah, and this isn't about just reciting the legal text, is it?
Yeah.
This handbook is, well, unapologetically pragmatic.
Right.
It pulls out the essential insights, aims to provide clarity where the act is maybe a bit vague, offers structure, and gives practical direction based on real-world experience with other complex EU laws, like GDPR.
So it's designed to be your map now.
Exactly. Your map for today.
And why does this matter to you, the listener? Well, whether you're building AI systems, deploying them in your business, or you're simply impacted by AI operating in or affecting people in the EU.
Or even outside it sometime.
Exactly. Understanding this law is non-negotiable. This deep dive is crafted to give you a clear pathway through its complexities. Let's jump into what the handbook covers, starting with its introduction.
Okay, so the handbook opens by acknowledging the reality we just discussed. AI is no longer just a research concept. It's deeply integrated into business operations globally.
Yeah, everywhere. Optimizing logistics, powering customer service.
All sorts of things.
And the regulatory response from the EU, the AI Act, is described as wide-ranging, top-down, and importantly, still in flux. That creates immediate tension for businesses, right?
Exactly. How do you build a robust compliance program when the law is perceived as vague in parts, still evolving, and, well, even experts don't always agree on its interpretation?
That's the big question.
That's the conundrum this handbook is built to address. It kind of bypasses being a purely academic legal analysis and focuses on pragmatic answers for businesses today.
Grounding its interpretations in what's likely to hold up in court.
Precisely. What's likely to fly with the EU courts?
So it's not a magic wand for all the uncertainty, but it gives you that crucial map for action.
Definitely.
The handbook highlights right away the sheer density of the act. I mean, hundreds of pages, complex terms, cross-references.
Oh, yes.
And it regulates two distinct concepts, AI systems and general-purpose AI models, or GPAI models.
And to illustrate that fundamental definition of an AI system, they use a simple, relatable example, an automated email routing tool.
Great.
If that tool just uses simple if-then rules based on keywords like if invoice is in the subject route to finance,
Yeah.
it's probably not an AI system under the Act.
Right, that sounds like standard automation.
Exactly. But if that same tool uses complex language processing trained on data to understand the sentiment or intent of an email,
Oh.
figuring out it's a complaint, an order, or a request for a refund based on context, and then routing it based on that inference, that's far more likely to fit the definition of an AI system.
Makes sense. It's about the inference.
Right. But even with guidance from the European Commission, the handbook notes that drawing a clear line between sophisticated non-AI software and an AI system remains difficult.
So that core definition, which they promise to explore more later, is one of the key areas of ambiguity businesses face right from the start.
Absolutely. Foundational ambiguity.
Navigating this kind of uncertainty is a running theme, isn't it? And the introduction offers some practical tips for doing just that.
Yeah, it does. One is to learn from the past. The handbook draws parallels to the early days of GDPR.
Ah, good comparison.
Remember how key interpretations around things like data transfers and transparency weren't immediately clear?
Vaguely, yes. Lots of debate.
They evolved significantly over time through regulatory guidance and court decisions. They anticipate a similar journey for the AI Act.
That historical perspective is valuable. It reinforces that you can't wait for perfect clarity. You need to start building your compliance approach now, expecting it to adapt.
Exactly. Which leads to another tip. Look to other EU laws. The AI Act doesn't exist in isolation.
Right.
Understanding how courts, like the Court of Justice of the EU, have interpreted similar broad laws using principles like Purposive interpretation,
Mm.
focusing on the law's objective, can offer clues for how the AI Act might be interpreted where it's ambiguous.
So it's about drawing on the vast experience navigating the EU's whole legal landscape.
Precisely.
The third key tip from the handbook is incredibly practical. Seek progress over perfection.
Yes, this one is key.
Don't let the complexity paralyze you. Starting to build your compliance foundations now, even with some uncertainty, is far better than doing nothing.
Totally agree. If regulators come knocking, demonstrating a program underway shows good faith and effort. Much better position to be in.
Absolutely. The handbook is explicitly designed to help businesses start quickly on that journey.
And the fourth tip is vital, given the pace of change. You must stay up to date.
Constantly evolving.
Monitor new guidance, regulatory decisions, real-world implementation feedback. Resources like the handbook itself and the EU's AI Watch are highlighted as essential tools for this ongoing monitoring.
And finally, the introduction offers a sobering but perhaps a slightly reassuring point on enforcement timing.
Yeah, this is important. Immediate, aggressive, large-scale enforcement with maximum penalties isn't likely for most businesses right away.
Why is that?
Well, national regulators need time to set up their enforcement structures and understand their powers. They might also be hesitant to issue massive fines based on interpretations that haven't been tested in court yet.
Risking those decisions being overturned on appeal.
Exactly. Smaller penalties for less clear-cut issues might be less likely to face costly appeals, potentially guiding early enforcement.
And crucially, the handbook notes that the Act's enforcement itself is staggered over several years for different types of systems.
Which we'll definitely get into later.
So while the law is in force, the immediate pressure cooker isn't uniformly high for everyone on day one.
That's a good way to put it. It's not zero pressure, but maybe not maximum pressure immediately everywhere.
Okay, that sets the stage really well. Now let's move into one of the most critical areas for any business, the scope and application of the EU AI Act. Who does it apply to and under what circumstances?
Right, Chapter 2. The handbook summary on this is pointed. It applies to a wide range of roles across the AI value chain, and it has an aggressive extraterritorial reach.
That extraterritoriality point is a big one, isn't it?
Huge. The Act can apply to businesses outside the EEA, even if they have no deliberate intention of doing business there.
Wow. Okay, so the handbook breaks down the parties involved. Unlike GDPR, which mainly focuses on two roles, controller and processor, the AI Act identifies at least 6 distinct roles.
That's right. First up, you have the provider. This is the entity that develops an AI system or a GPAI model, or has one developed, and places it on the EU market, or puts it into service under their own name or trademark.
And the key thing is, they don't have to be located in the EEA if their system's output is used here.
Correct. If the output lands in the EEA, they could be in scope.
Okay. Then there's the deployer.
That's basically anyone using an AI system under its authority except for personal, non-professional use. So a business using an AI tool internally, that's a deployer.
Got it.
A non-EEA provider might appoint an authorized representative. That's an EEA-based intermediary who acts on their behalf regarding the Act's obligations based on a written mandate.
Then an importer.
An importer is an EEA-based organization that takes a non-EEA AI system and places it on the market under the non-EEA entity's name or trademark.
Okay, slightly different from the authorized rep.
And a distributor is simply any entity making an AI system available on the market other than the provider or importer. Basically, anyone else in the chain passing it along.
There's also the manufacturer of a product, if that product incorporates an AI system and is placed on the market.
Right. And the handbook also mentions the concept of an affected person, that's individuals impacted by AI, and operator, which is a broad catch-all term.
But the rules apply based on the specific role, like provider or deployer, not just being an operator.
Exactly. The obligations are tied to the specific function you perform.
Now, let's revisit that aggressive territorial scope. This is fascinating. The original Draft Act and some recitals suggested that intending for the output to be used in the EEA was the trigger for non-EEA businesses.
Right. But the handbook highlights that the final text, specifically Article 2.1c, seems to drop that requirement of intent. It says the Act applies if the output is used in the EEA, regardless of whether the non-EEA business intended it for that market.
That is a critical point of potential surprise for global businesses.
Absolutely. It's a huge potential expansion of scope.
To make this concrete, the handbook offers a powerful example. Let's walk through it.
Okay. A Japan-based ad agency, Company X, uses an AI design tool. So Company X is a deployer of that tool.
Right.
They use it to create branding for a client in Argentina, Company Y. Later, Company Y, the client, uses that branding in Spain, which is in the EEA.
Okay, so the output ended up in the EU.
Exactly, under a literal interpretation of the Act,
Yeah.
because the AI system's output, the branding, is used in the EEA, the Japan-based ad agency, Company
Who
X.
had no direct business in Spain.
Could be subject to the EU AI Act as a deployer, even if they had no intention or knowledge that their client would use the output in the EEA.
Wow. And the handbook suggests that even a contract prohibiting the client from using the output in the EEA might not be legally sufficient to avoid jurisdiction.
That's the potential interpretation highlighted. It really shows the breadth we're talking about. Intent might not matter as much as actual use of the output.
It's a complex web. And the handbook also notes the complex relationship with other EU laws. The Act states it's without prejudice to laws like GDPR, meaning it's not intended to override them.
Right. Without prejudice sounds simple, but the practical implications are far from it. There's potential for significant overlap and, frankly, legal uncertainty that will need future clarification.
And the handbook highlights the potential for parallel liability.
Yes, this is a major concern. If an AI system processes personal data and causes an issue, say a data breach or discriminatory output,
Right.
you could potentially face legal action and fines under both GDPR and the AI Act for the same incident.
And the cumulative financial impact could be enormous. The handbook calculates the potential aggregate maximum fines. What were they again?
Up to 20 million or 4% of worldwide turnover under GDPR, plus 35 million or 7% under the AI Act.
So potentially 55 million or 11% of worldwide turnover.
Potentially, yes. Plus any separate damages claims under either law. That certainly underscores the need to understand both regimes very, very carefully.
No kidding. Okay, let's delve deeper into those core definitions, as the handbook does in Chapter 3. These are critical, right? Everything flows from these.
Absolutely. While they might seem straightforward at first glance, these definitions are critical for determining the scope and application. And the handbook points out they're intentionally flexible to accommodate future technology.
Which unfortunately injects uncertainty.
Exactly. Businesses need to extrapolate from other EU laws and, frankly, hope for regulatory guidance and case law down the line.
The definition of an AI system is particularly detailed and worth breaking down piece by piece, as the handbook does. First part, machine-based system.
Okay, that part's simple enough. It's software, hardware, or both.
But then it gets into the nuances. It must be designed to operate with varying levels of autonomy.
Right. The handbook references the recitals defining autonomy as having some degree of independence from human control during operation. Commission guidelines clarify that systems with full manual human involvement are out of scope.
But varying implies a range of independence, not necessarily that the level changes over time.
That seems to be the interpretation. And a literal reading might suggest any degree of autonomy is enough. But the guidelines seem to push for some reasonable degree. It's a subtle distinction.
It also must be a system that may exhibit adaptiveness after deployment, meaning it can change or learn once it's out in the world.
Yes, it's not static. It can evolve based on new data or interactions.
And importantly, it must operate for explicit or implicit objectives.
Right. Explicit goals are those programmed by the developer, like maximize click-through rate. Implicit goals are those the system might deduce from its behavior or assumptions, which might even differ from the developer's original intended purpose. The Act covers both.
Okay. The core function is that it infers from the input it receives how to generate outputs.
This inferring is key, the handbook stresses. The system isn't just following pre-programmed fixed rules. It's independently deriving outputs based on patterns it's learned or identified in the input data. Think image classification, medical diagnostics, fraud detection trained on complex data sets.
And this is contrasted with systems using simple statistical rules or averages, like calculating average stock prices or temperature trends.
Exactly. Those systems have, as the guidelines put it, limited capacity to analyze patterns and adjust autonomously in the way an AI system does. But the handbook acknowledges this boundary remains subtle and elusive in practice. It's not always a bright line.
The outputs can be terreport, such as predictions, content, recommendations, or decisions.
And the such as is important. These are examples, not an exhaustive list. Any output derived through this kind of inference could potentially qualify. The The guidelines emphasize that AI systems handle complex relationships and patterns differently for these outputs compared to non-AI systems.
And finally, the system must be one that can influence physical or virtual environments.
Yeah, this one's a bit vague. The handbook finds it unclear in the recitals.
Mhm.
Basically, it means the system must have some identifiable impact either in the real world, like controlling a robot arm.
Or in digital contexts.
Right. Like influencing data flows, maybe changing content on a website, affecting software ecosystems, some tangible or digital effect.
A significant ambiguity highlighted by the handbook is this tension between a system being designed for autonomy versus autonomy emerging unexpectedly during deployment.
Hmm.
If it's designed for autonomy but never actually achieves it in practice, is it still covered?
The handbook says that's unclear based on the text alone.
Conversely, if it wasn't designed for autonomy but sort of develops it through learning in real-world use, is it an AI system then?
A literal reading of Design to Operate might say no, but the handbook suggests courts and regulators might look at the actual behavior, the facts on the ground.
And commission guidelines from early 2025 suggest.
They suggest the definition elements don't need to be present continuously across both design and use phases. So if autonomy emerges during deployment, it can still be classified as an AI system.
Yeah.
But yeah, this area definitely requires future clarification.
Another critical definition, provider. As we noted, this is one of the key compliance roles.
Absolutely.
The definition states it's an entity that develops or has developed an AI system or GPAI model, and two, places it on the market or puts it into service under its own name or trademark.
And the handbook points out the ambiguity of that little linking word, and.
How so?
Well, if it's read conjunctively, meaning you must do both developing and placing on the market under your own name, then in many real-world scenarios, like white labeling or using components from others, there might be no single entity that fits the definition perfectly.
Leaving a potential gap in responsibility.
Exactly. But if it's read disjunctively, meaning you just need to do either developing or placing on the market under your name, then multiple parties could potentially qualify as the provider for the same system.
Which creates uncertainty about who is responsible for which obligations.
Precisely. Who has to do the risk assessment, who does the documentation, who affixes the CE mark. This kind of definitional ambiguity at the core of the Act creates real challenges for assigning compliance duties.
Okay, moving into Chapter 04, the handbook introduces a concept relatively new in this kind of regulation, AI literacy.
Yes, this is Article 356. The core idea is that providers and deployers aren't just responsible for the tech itself. They also have a requirement to ensure the people using or operating that technology have sufficient understanding.
AI literacy, as defined, means having the skills, knowledge, and understanding needed. For whom?
For providers, deployers, and even affected persons, interestingly. The goal is to enable informed deployment and operation of AI systems, with awareness of the opportunities, but crucially, also the potential risks and harms. It takes into account their respective rights and obligations under the Act.
So the requirement falls specifically on providers, the developers, and deployers, the users.
Yes, they must take measures to ensure their staff or anyone operating the AI on their behalf has an adequate level of this literacy.
And the overarching goal is?
Basically, personnel should be capable of using the systems responsibly, understanding the potential downsides, the risks, the ethical considerations, as well as the benefits. It's about competent and aware human interaction with the AI.
Makes sense. Okay, Chapter 05 gets into the really sharp end. Prohibited AI practices.
Article 5, the stuff that's just banned outright.
The executive summary here is straightforward. There are specific uses of AI that are banned, and this list isn't static, right?
Correct. It's subject to annual review and potential change by the European Commission. That annual review process, starting in August 2024, is key.
So the Commission assesses the need to amend the list of prohibited practices yearly and can propose changes.
Yes. They submit findings to the Parliament and Council. This means businesses need not only to ensure they aren't currently engaging in these practices, but also establish a process for monitoring future amendments to Article 5. The list will likely change over time.
What are some of the specific prohibitions that the handbook highlights as relevant for businesses? Let's walk through them.
Okay, first, using subliminal, manipulative, or deceptive techniques. Art by 51A. This prohibits systems deploying these techniques with the objective or effect of materially distorting behavior in a manner causing or likely to cause significant harm.
So AI designed to subtly influence decisions or actions in a harmful way without the person really being aware.
Exactly. Think dark patterns on steroids, potentially.
Second.
Systems that exploit vulnerabilities based on age or physical mental disability,
Yeah.
Article 5.1. Again, the key is distorting behavior and causing significant harm. This is about protecting vulnerable groups from harmful manipulation by AI.
Third one.
Biometric categorization based on sensitive attributes, Art.5.1.d. This bans AI that categorizes people using biometric data like face scans, voice patterns to infer sensitive traits.
Such as race, political opinions, religious beliefs, sex life, sexual orientation.
Correct. Those kinds of sensitive categories. There are limited exceptions, mainly for law enforcement in specific permitted contexts,
Right.
but for general business use, it's largely prohibited. Creating or expanding facial recognition databases through untargeted scraping of images from the internet or CCTV footage, Art.5.1, the handbook points out the focus on untargeted. A literal reading suggests targeted scraping, maybe within a specific location or context, might not be prohibited by this specific clause. Other rules might still apply, of course.
Interesting nuance. And the fifth one.
Inferring emotions in the workplace or educational institutions, Art.Pod 5.1. This is prohibited unless it's strictly for medical or safety reasons, like therapeutic use for health conditions. So no AI monitoring employee mood swings or student stress levels generally.
The handbook doesn't explicitly give a full example here, but we can infer one, like
Uh-huh.
an AI system used on a digital billboard.
Yeah, if that system scans faces to infer sensitive attributes like ethnicity or religion for targeted advertising, that would likely fall under the prohibited biometric categorization, right?
Seems likely.
Or if it tried to infer emotions to gauge audience reaction in a store, which could be considered a workplace for the employees there.
That would be prohibited under the emotion inference rule, unless it was, say, monitoring patient well-being in a hospital setting.
Exactly. The compliance challenge is ensuring your AI system doesn't trip any of these specific red flags. You have to check against all the prohibitions listed in Article 5.
Okay, got it. Now, one of the most impactful parts of the Act for businesses is the classification of AI systems as high risk, Chapter 6. This determination triggers a whole host of stringent requirements.
It really does. And the handbook's executive summary here makes a crucial point. While the Act is often described as risk-based, the classification itself is primarily category-based.
Meaning it's not based on a nuanced assessment of the actual risk in a specific use case.
Largely no. Article 6 and Annexes I and 3 define high-risk systems based on the category or intended purpose they fall into. An AI system that poses a genuinely high risk in practice but doesn't fit one of the defined categories is technically not high risk under the Act.
And the flip side, a system that fits a high-risk category is considered high risk.
Even if its actual real-world application in a particular context seems to pose a relatively low level of danger or fundamental rights impact.
The handbook flags this category versus actual risk discrepancy as a source of complexity and potential uncertainty.
It's a major point of discussion. So there are two main paths to being classified as high risk. The first is under Article 6.1.
Which covers?
AI systems intended to be used as a safety component of products covered by specific existing EU harmonization legislation listed in Annex 2.
Okay, so these are products already subject to EU safety rules, like gas appliances, machinery, medical devices, personal protective equipment, toys.
Exactly. The handbook lists quite a few. If an AI system is a safety-critical part of these products, think AI in a lift maintenance system, diagnostic software in a medical device, safety sensors and protective gear, it's high risk under this path.
Got it. What's the second path?
The second and arguably broader path is under Article 6.2. AI systems used in specific areas listed in Annex 3. This is where many novel AI applications are likely to fall.
And Annex 3 covers a wide range, doesn't it?
It does. Areas like biometrics, with some exclusions, critical infrastructure, like AI, used for safety components in managing the electricity grid or water supply, or transport traffic control.
Education and vocational training.
Yes, systems determining access or admission, evaluating learning outcomes, assessing appropriate levels, or even monitoring for prohibited behavior like cheating.
Employment and worker management.
Definitely. Recruiting tools, performance monitoring, decisions affecting terms of employment or promotion.
Access to essential private and public services.
Things like credit scoring systems or AI used for dispatching emergency services like ambulances or fire brigades.
Law enforcement uses.
A whole category here. Risk assessments of offenders or victims, evaluating evidence reliability, profiling, detecting crime, even polygraph-like systems.
Migration, asylum, and border control.
Certain uses by competent public authorities fall into this category.
And administration of justice and democratic processes.
Yes, AI used by or on behalf of judicial authorities for research, interpreting law or facts, applying law, or even in alternative dispute resolution. It's a very broad list in Annex 3.
However, the handbook points out that Article 6.3 provides specific exclusions. An AI system is not high risk, even if it fits into an Annex 3 category, provided it meets certain criteria.
Right. The handbook highlights two main ones. First, if the system is intended only to detect decision-making patterns or deviations and is not meant to replace or influence a previously completed human assessment.
Like an AI that just flags potential inconsistencies in financial data, but a human still makes the final call.
Exactly. It's purely assistive in identifying anomalies, not making or influencing the core assessment.
What's the other exclusion?
Systems intended to perform a mere preparatory task for a risk assessment. The handbook lists examples like smart filing, indexing documents, searching databases, text or speech processing, linking data, or machine translation tools that facilitate human analysis but don't perform the core assessment themselves.
The handbook implicitly notes that a system might also not be high risk if it poses a low level of actual real-world risk. But this is where that category versus risk complexity comes in again.
Yes, the category generally overrides a low real-world risk assessment. If it's in Annex 3 and doesn't meet an exclusion, it's high risk, period.
So for businesses trying to figure out if their system is high risk, what's the advice?
Well, the handbook mentions that commission guidelines with practical examples are expected by February 2026. Until then, it's mainly the text of the Act itself.
The first practical step is just understand your own AI.
Pretty much, get a very clear picture of how your business uses AI systems and what their intended purposes are. That forms the necessary basis for any high-risk assessment and figuring out if any exclusions might apply.
The commentary stresses that the Act's attempt to be technology neutral creates complexity here. Ambiguity in Article 6 and Annex 3 leaves gray areas.
And businesses need to consider that intended purpose carefully, accounting for potential foreseeable misuse by users, or systems that might have multiple intended purposes, some high risk, some not.
Okay, so let's say you've determined your AI system is classified as high risk. The next question the handbook tackles in Chapter 07 is, what are the requirements?
And the summary is clear. These are stringent and mandatory, no wiggle room here.
Exactly. These requirements, spanning Articles 8-15, cover a lot of ground. Continuous risk management, data quality, documentation, logging, transparency, human oversight, accuracy, robustness, cybersecurity.
It's a comprehensive list. Let's start with risk management systems. Article 9. Providers of high-risk systems must establish, implement, document, and maintain a comprehensive risk management system for each system.
And this isn't a one-off check.
No, it's described as an ongoing iterative process throughout the system's entire life cycle.
What does it involve?
Identifying and analyzing risks, not just health and safety, but also fundamental rights risks, evaluating risks that might emerge during use or from post-market monitoring data, and then adopting appropriate measures to control those risks.
Next, data governance and management, Article 10. This is deemed critical, particularly for data quality and bias mitigation.
Absolutely. Providers must put in place practices to detect, prevent, and mitigate biases that are likely to negatively affect fundamental rights, health, or safety, or lead to unlawful discrimination.
Including identifying and addressing data gaps or shortcomings.
Yes, making sure the data is fit for purpose and doesn't encode harmful biases.
The handbook notes a specific point regarding sensitive personal data, SCD, generally restricted, but
Processing SCD is exceptionally permitted under Article 10.5, solely for the purpose of bias correction. But this comes with very strict safeguards. Compliance with data protection laws like GDPR, ensuring it's the only effective way to correct the bias, protecting the SCD, deleting it once the bias is corrected, and maintaining records of the processing. It's a narrow exception.
providers also need robust technical documentation, Article 11, prepared before placing the system on the market.
Right. This documentation must demonstrate compliance with all the high-risk requirements in Articles 8.15. It's basically the evidence file that allows authorities to assess conformity.
And Annex 4E details what's needed, which can be updated later by delegated acts.
Correct. It's a living requirement.
Record keeping, Article 12, mandatory for high-risk systems requiring automatic event logging.
Yes, the system needs to generate logs automatically, appropriate to its intended purpose to ensure traceability.
And what are these logs for?
They're crucial for identifying risks that might emerge, facilitating post-market monitoring, and simply monitoring how the system is operating. They provide a critical audit trail if something goes wrong or needs investigation.
Transparency and provision of information, Article 13. High-risk systems must come with clear, comprehensive instructions for users.
Yeah, this includes details about the system's intended purpose, how it functions, its performance characteristics, any limitations, foreseeable risks.
Required human oversight, the type of input data it needs, necessary human expertise for operation, and instructions for monitoring. Basically, a detailed user manual focused on safe and compliant operation.
Pretty much.
Human oversight, Article 14. This sounds fundamental.
It is. High-risk systems must be designed to allow for effective human oversight. Providers need to implement measures to minimize risks to health, safety, and fundamental rights through human intervention capabilities.
And the specific nature of these measures depends on the system.
Exactly. It will vary greatly depending on the system and its application context. What oversight looks like for a medical diagnostic tool will be different from a recruitment system.
Finally, the technical performance requirements in Article 15: accuracy, robustness, and cybersecurity.
Right. High levels of accuracy are mandated, measured using appropriate metrics relevant to the intended purpose.
Robustness means
The system must perform consistently, handle errors and inconsistencies gracefully, and be resilient to potential issues or attacks throughout its life cycle.
and cybersecurity.
Appropriate measures against cyber attacks, prevention, detection, response, resolution, and control at a level suitable for the circumstances and risks involved. It needs to be secure.
The handbook commentary simply notes that Articles 815 represent a complex set of obligations that providers must satisfy. No shortcuts.
That's the message. It's a high bar for high-risk systems.
Okay, so beyond the requirements for the system itself, Chapter 08 details the specific obligations placed on the different actors relating to high-risk AI systems.
Right, the who does what part.
The summary highlights stringent duties for providers and deployers, but less burdensome ones for others, like authorized representatives, importers, and distributors.
And it also points out that different parties have different obligations. And sometimes those other parties, importers, distributors, can even step into the provider role and inherit all those obligations.
This section, covering Articles 1627, clarifies these roles. The primary obligation of providers, Part 16, is ensuring their systems comply with the ART's Point 815 requirements we just discussed. But they have numerous additional duties on top of that,
Such as?
indicating their name and contact information, establishing and maintaining a quality management system, QMS, keeping necessary documentation, maintaining automatic logs, undergoing conformity assessment.
Drawing up the EU Declaration of Conformity, affixing the CE marking, complying with registration requirements, taking corrective actions if needed, cooperating with authorities, and complying with accessibility requirements.
It's a comprehensive list of ongoing responsibilities for the provider.
Definitely. And that quality management system, QMS, mentioned in Article 17 for high-risk providers, is explicitly required to ensure compliance. It must be documented.
What needs to be in the QMS?
Things like a regulatory compliance strategy, design development procedures, testing protocols, technical specs, data management processes, the risk management system itself, post-market monitoring plans, serious incident reporting procedures, communication processes with authorities, record-keeping systems, resource management, and a clear accountability framework defining responsibilities.
Sounds pretty expensive.
It is, but the handbook notes that proportionality applies, our point says in R2. It should be proportionate to the organization's size. Recital 146 allows for a simplified manner for microenterprises, recognizing the burden this could otherwise place on small entities. Commission guidelines on this are expected.
And financial institutions have extra QMS obligations.
Yes, they have specific additional requirements layered on top.
Providers must also keep the automatically generated logs, Point 19, required under Article 12.1, under their control. For how long?
At least 6 months, unless other EU or national law mandates longer. Financial institutions also face extended logging duties here too.
A critical obligation seems to be corrective actions and the duty of information, Art.20.
Absolutely. If a provider considers, or has reason to consider, that a system already on the market isn't in conformity, they must immediately take action.
Which could mean
Bringing it back into conformity, withdrawing it from the market, disabling it remotely, or recalling it, whatever is necessary.
and they must inform everyone else in the supply chain, distributors, deployers, authorized reps, importers.
Yes. And if they become aware that a system poses a risk to health, safety, or fundamental rights, they must immediately investigate and inform the competent market surveillance authority and the notified body, if one was involved.
The handbook points to Recital 115, suggesting this reason to consider nonconformity is expected to be detected through their own post-market monitoring systems. Art.72.
Right. It implies an active duty to look for problems.
Cooperation with competent authorities, Art.21, is also mandated. Providers have to furnish necessary information and documentation upon a reasoned request to demonstrate compliance.
Standard stuff for regulated products.
For providers based outside the EEA, Art.22, appointing an EEA-based authorized representative via a written mandate is mandatory.
Yes, mandatory before placing a system on the market. The representative has specific tasks like verifying the provider's declarations and documentation, confirming conformity assessment was done, providing information to authorities, cooperating with them, and complying with registration.
Yeah.
Their responsibilities are set out in the mandate.
Okay, now shifting to the obligations of deployers, Art.26, what do they need to do?
They need to use the systems according to the provider's instructions, ensure any required human oversight measures are properly implemented by their staff, monitor the system's operation based on the instructions.
Ensure input data is relevant and sufficient for the intended purpose, suspend or terminate use if a risk is detected during operation, and keep logs if they are under the deployer's control.
And a key obligation for certain deployers is the Fundamental Rights Impact Assessment, or FRIA.
Who needs to do this FRIA?
Deployers must perform a FRIA before the first use of high-risk systems listed in Annex 3 that are used by public authorities or operators acting on their behalf. So it's specifically tied to public sector or quasi-public sector use of certain high-risk systems.
What needs to be in the FRIA?
The handbook details the content, a description of the intended use, how long, how often, who is affected, categories of persons, specific risks identified for them, the human oversight measures in place, and the risk mitigation measures, including governance structures and complaint processes.
Can deployers rely on previous work?
Yes, importantly, they can rely on previous FRAs conducted for similar use cases, or even on assessments provided by the system's provider. And they generally need to notify the Market Surveillance Authority of the FRIA results unless they qualify for an exemption.
A practical tip from the handbook for deployers is to integrate the required post-market monitoring, which is detailed later in Art.72, into their existing operational systems.
Yeah, to avoid duplication and ensure comprehensive compliance. Makes sense. The commentary also reiterates that importers, distributors, and authorized representatives have their own set of less stringent but still important obligations, mainly focused on checking for basic compliance indicators like the CE marking before making systems available, and informing authorities if they suspect non-compliance.
Okay, Chapter 09 outlines the infrastructure behind compliance, notifying authorities and conformity assessment bodies. This is about the system set up to verify that high-risk systems actually meet the requirements.
Exactly. This is the oversight structure. Member states are responsible for setting these up. Notifying authorities are established by member states to manage, assess, and monitor the bodies that perform the conformity assessments.
And those bodies are called conformity assessment bodies, or CABES.
Right. They perform third-party testing, certification, or inspection of AI systems. A notified body is a specific type of CAB that has been officially designated by a member state and notified to the European Commission and other member states.
So, to become a notified body, Art. 3.1, these organizations must meet rigorous standards.
Yes, standards of competence, independence, and impartiality. Crucially, they cannot be the provider or deployer of the AI system they are assessing to avoid conflicts of interest.
And their core operational obligation, Art. 3.4, is performing the conformity assessments for high-risk systems, as detailed later in Article 43.
Correct. The handbook notes they need to strike a balance, minimizing burdens for providers, especially SMEs, while still ensuring rigorous compliance with the required standards. They also have to cooperate with their notifying authority, providing documentation if requested.
For guidance on meeting the requirements for notified bodies, the handbook suggests looking at similar rules under other EU laws.
Yes, like the Medical Devices Regulation, MDR, as the AI Act's specific requirements in Article 31 are somewhat limited in detail. So looking at how those requirements are interpreted elsewhere can provide useful pointers. This whole infrastructure is the backbone for getting independent verification for certain high-risk systems.
Okay, that leads us to Chapter 10, which goes into the specifics of how high-risk systems demonstrate compliance. Standards, conformity assessments, certificates, and registration. This chapter really connects the dots between the requirements, Chapter 7, obligations, Chapter 8, and the actual process of getting a system approved.
Exactly. Articles 40-49 detail these crucial processes. A key tool here is harmonized standards. Art 40.
What are those?
These are technical standards developed by European standardization bodies based on a request from the Commission specifically for the AI Act. Compliance with these standards provides a very important benefit, a presumption of conformity with the EU AI Act requirements covered by the standard.
So follow the standard, and you're presumed compliant for that aspect.
Essentially, yes, it simplifies demonstrating compliance significantly.
But what if the standardization process fails, or the standards aren't good enough?
Then the Commission can step in and set common specifications, Art 41, via implementing acts. These act as a backstop.
And these also provide a presumption of conformity.
Yes, when complied with. However, they are repealed if harmonized standards covering the same area are published later. Standards are preferred, specifications are the fallback.
Okay, the core of demonstrating compliance is the conformity assessment, Art 143. This is the actual process providers follow, two main procedures described.
Yes. First, the internal controls procedure, laid out in Annex 6. In this case, the provider basically self-assesses. They verify their own quality management system, technical documentation, and development processes align with requirements. Critically, this procedure does not involve a notified body.
And the second procedure?
That's the quality management system plus technical documentation assessment detailed in Annex 7. This procedure requires the involvement of a notified body. The notified body assesses the provider's QMS and technical documentation according to detailed requirements in Annex 7 and can conduct periodic audits or tests.
How does a provider know which procedure to follow? It seems complex.
It depends. You generally must follow the Annex 7 procedure, requiring a notified body if 1. No harmonized standards or common specifications are available covering your system's requirements, or 2. You haven't fully applied those standard specifications, or 3. The standard specifications include restrictions, in which case Annex 7 applies just to the restricted part.
However, there's a big exception.
Yes. There's a specific rule for providers of certain high-risk systems listed in Annex 3, paragraphs 2 through 8.
That's the list including critical infrastructure, education, employment, essential services, law enforcement, immigration, justice, and democracy.
Correct. For these specific categories, providers must follow the conformity assessment procedure based on internal controls, Annex 6, which, remember, does not require a notified body.
So the handbook notes a potential point of confusion here, because the first rule says use Annex 7 if no standards, but the second rule says use Annex 7 for these categories.
Exactly. It suggests a potential conflict or hierarchy. Does the specific Annex 3 category rule override the general rule about needing Annex 7 when standards are missing? The text seems to imply the Annex 6 rule takes precedence for those categories, but it could use clarification.
What about high-risk systems covered by other EU laws, like medical devices?
They must follow the conformity assessment procedures under those laws, like the MDR, but they have to integrate and demonstrate compliance with the AI Act requirements within that process, Art 433.
Can providers choose their notified body?
Generally, yes. For Annex 7 assessments, they can choose any available notified body, except for systems used by law enforcement, immigration, asylum authorities, or EU institutions. Those require assessment by the relevant market surveillance authority itself, Art 431.
Are there any exceptions to conformity assessment altogether? Article 46.
Yes, very limited exceptional circumstances. A market surveillance authority can grant temporary authorization, Court 4361, for urgent reasons like public security, protecting life or health, environmental protection, or critical assets.
But the authority must first conclude the system does comply with the requirements, and the full assessment is still needed promptly.
Correct. It's a temporary measure based on an initial compliance check.
There's also an exemption for temporary use by law enforcement or civil protection without prior authorization.
Yes, under Article 406(2, for truly urgent situations involving public security or specific imminent threats to life or safety. But, crucially, authorization must be requested during or immediately after the use.
And if authorization is refused,
Use must stop immediately, and any results obtained must be discarded.
these exceptional authorizations involve notification to the Commission and other member states who can object.
Yes, they have 15 days to object. The Commission can ultimately decide an authorization is unjustified, requiring the MSA to withdraw it. There are provisions to protect sensitive operational data for law enforcement uses.
Once conformity is established through the relevant procedure, what happens next?
The provider draws up an EU Declaration of Conformity, Art 47. This is a formal statement that the system complies with the Act. Annex V details the content, and this annex can also be updated by delegated acts.
And for high-risk systems, the CE marking Art 48 must be a fix.
Yes, this marking visually signifies conformity with the Act and potentially other relevant EU laws.
Mhm.
If the system itself is too small or it's not practical, it goes on the packaging or accompanying documentation.
Finally, certain high-risk systems have registration Art 49 obligations in the EU database, which we'll discuss more later.
Right.
The handbook uses that example of an AI system for education admission. It falls under Annex 3rd, Paragraph 3, making it high risk.
Right.
It must comply with Articles 815. If standards exist and are fully applied, presumption of conformity. If not, you'd normally think Annex the 7th notified body, but because it's Annex the 3rd, Para 3, the specific rule kicks in.
Mandating the Annex 6 internal controls procedure instead.
Hmm.
No notified body required for that specific category, regardless of standards availability, it seems.
This example really underscores how the specific Annex 3rd category dictates the assessment route, highlighting that potential ambiguity we mentioned.
Definitely. You need to check your specific Annex 3 category very carefully.
Okay, let's move to transparency obligations in Chapter 11, Article 50. The summary here points out that transparency requirements aren't one size fits all.
No, they vary significantly depending on the type of AI system. Is it interacting with people, generating synthetic content, using biometrics, creating deepfakes, generating news-like text?
So you really need to review your specific systems carefully. And there are exceptions too.
Always exceptions.
The concept of transparency isn't given a single rigid definition, but the handbook refers to Recital 27, which lays out the principle.
Yes, Recital 27 talks about traceability, explainability, humans being aware they're interacting with AI, deployers understanding the system's capabilities and limitations, and affected persons being informed of their rights. It's about openness and understandability.
So the specific obligations are detailed in Article 50. First, for AI systems intended to interact with individuals, Art 50.
Users must be informed that they are interacting with an AI system unless it's obvious to a reasonably well-informed person.
The handbook cautiously advises against relying heavily on that obvious exception.
Yeah, courts might interpret that narrowly. Better to disclose unless it's really obvious, like interacting with a clearly robotic voice assistant, maybe? This rule applies broadly unless the system is outside the Act's scope or authorized for law enforcement, with caveats.
Second, for AI systems that generate synthetic content, Art 52, like text, images, video.
Providers must ensure that these outputs are marked as artificially generated or manipulated. This needs to be done using effective technical solutions like watermarking or metadata, as far as feasible.
And this applies quite broadly to text generators, chatbots, AI-assisted editors.
Yes, if they generate or significantly manipulate content, there are exceptions. Systems outside scope, authorized for law enforcement, with caveats. Those used primarily for standard editing assistance, like spell check, or outputs that don't substantially alter the input data, although the handbook notes this last point is ambiguous and needs guidance. What counts as substantial alteration?
Good question. Third, for AI systems using biometric categorization or emotion inference, Art 0.
Deployers must inform the individuals who are subject to these systems that they are in operation. Again, applies unless outside scope or authorized for law enforcement, with caveats.
So this could cover systems tracking crowd reactions to ads or categorizing people based on physical traits or inferred preferences.
Exactly. If you're using AI to read faces for emotions or categorize people biometrically, you need to tell the people being subjected to it.
Fourth, AI systems that generate or manipulate images or videos to create deepfakes, Art 54.
Deployers must disclose that the content is artificially generated or manipulated. If the deepfake is part of an artistic, creative, satirical, or similar work, the disclosure needs to be appropriate without hindering the enjoyment of the work.
And a deepfake itself is defined elsewhere as content resembling an existing person, object, or event, but falsely appearing authentic.
Correct. Standard exceptions apply here too, outside scope law enforcement.
And fifth, also under Article 54, if an AI system generates or manipulates text that is published to inform the public on matters of public interest.
Yes, things like news articles, public warnings, health alerts, information related to fundamental rights, or even content described as fake news. If it's AI-generated or manipulated text intended to inform the public on these matters, the deployer must disclose that fact. Same exceptions apply as for deepfakes.
So the clear compliance implication from this chapter is check your systems.
Absolutely. Businesses need to undertake a careful review of all their AI systems to identify which of these different transparency obligations apply. It's not just one general rule, it's a layered set of duties depending on the system's function and output. You might trigger several or none.
Okay. Chapter 12 shifts focus specifically to GPAI models, general purpose AI models, and the concept of systemic risk. This sounds important.
Very important. The summary states that GPAI models, if they are deemed to pose a systemic risk, face significant additional obligations on top of the standard ones.
And this risk is assessed based on.
Two main ways. Either they have high impact capabilities or they are designated directly by the Commission.
Okay, Articles 51, 52, and 90 cover this. Systemic risk for GPII models, Art. 365, is defined as what exactly?
A risk specific to the high impact capabilities of these very powerful GPAI models, which could have a significant negative impact on the EU market or on public health, safety, security, fundamental rights, or society as a whole. Think large-scale potential harms.
How is systemic risk assessed? The handbook outlines two paths under Article 51.1. First,
Based on high-impact capabilities,
Hmm.
Art. 5100A, the provider assesses if their model's capabilities match or exceed those of the most advanced GPAI models currently available, using technical tools, indicators, and benchmarks. It's a self-assessment against the state of the art.
And there's a critical presumption here involving FLOPs.
Yes, Article 5192. A model is presumed to have high-impact capabilities if it was trained using a cumulative computation exceeding 1035 floating point operations, FLOPs. That's a massive amount of compute.
If a provider's model meets or exceeds this computational threshold, they must notify the European Commission.
Yes, within 2 weeks of knowing they've hit that threshold, Art. 52.
What's the second path to systemic risk designation?
Commission designation, Art. 51. The Commission can decide, either on its own initiative, ex officio, or based on input from the scientific panel, Art. 90, that a model has equivalent capabilities or impact, regardless of whether it meets the 1025 FLOPs threshold or the provider's own assessment.
How does the Commission make that call?
They assess it against criteria listed in Annex 13. This includes things like performance benchmarks, the range of tasks the model can perform, its adaptability, autonomy, scalability, whether it can access external tools, and its impact on the EU market, which is presumed if there are more than 10,000 registered EU business users, or based on end-user numbers.
So as the handbook notes, this second path creates a scenario where the Commission can designate a model as having systemic risk, even if the provider's own assessment says no.
Exactly. The Commission has the ultimate power to designate based on impact and other criteria, not just the FLOP count or the provider's view of its capabilities.
The scientific panel, composed of independent experts, plays a role here.
Yes, they can alert the Commission if they suspect a concrete identifiable risk at EEA level from a GPI model, or if they believe a model meets the conditions for having high-impact capabilities. They act as technical advisors and watchdogs.
Following such an alert or acting ex officio, the Commission assesses the model independently against Annex 13 criteria, informs the AI board, and can then use its enforcement powers.
Correct. That's the process outlined in Article 92 and 52.4.
What's particularly interesting here is the appeal procedure, Art. 524, described by the handbook. Providers have opportunities
Which the handbook describes as potentially unlimited.
to challenge a Commission decision designating their model as having systemic risk.
Yes, they can request a reassessment after 6 months, and the Commission must take that request into account, possibly reassessing against Annex 13 criteria. Subsequent requests are possible every 6 months, but they need to be based on compelling, novel arguments reflecting developments since the last decision. You can't just keep asking with the same old arguments.
The commentary highlights this appeal process as giving providers significant procedural leverage.
It does seem that way.
Yeah.
It suggests they may have more influence over the systemic risk determination than it might initially appear. And it definitely underscores the need for deep technical understanding to effectively challenge such a designation if you disagree with it.
The handbook provides an example. A U.S. company develops a GPAI model for analyzing financial data. A Spanish company uses this model via an API.
Okay.
The U.S. company is the provider. Because its model's output is used in the EEA, Spain, it's subject to the Act.
Right, extraterritorial scope again.
That U.S. provider must assess if its model has high impact capabilities, potentially triggering the 1025 FLOP's notification requirement within 2 weeks.
And the Spanish company, as a deployer and potentially a downstream provider integrating the model, needs to be aware of the U.S. provider's determination and any potential commission designation.
Exactly, because that systemic risk status impacts the Spanish company's obligations related to using the model.
And if the U.S. company doesn't notify, but the commission later designates the model anyway.
It could still trigger obligations for both parties down the line. It shows the interconnectedness.
Definitely.
Okay, Chapter 13 covers the general obligations that apply to all GPAI models, regardless of whether they have systemic risk.
Right. These are the baseline duties for anyone putting a GPAI model on the market in the EU.
The summary lists these: technical documentation, sharing information with entities downstream using the model, copyright compliance, and appointing an authorized representative for non-EEA providers, and that potential limited exemption for open source models.
Exactly. Articles 53 and 54 detail these duties. The key parties here are the provider of the GPA model and downstream providers. Those are providers of AI systems that integrate or use someone else's GPAI model.
First, technical compliance documentation, Art Pot 5381. Providers must prepare and maintain documentation describing the model.
Yes, and this needs to be available upon request by the AI office or national authorities in any member state where the model is accessible. Annex LS lists the minimum required information.
What kind of info?
Things like a general description, what tasks it does, acceptable use, parameters, and information on the training, testing, and validation data, including type, source, and curation methods, also details about the architecture.
And this documentation is subject to intellectual property rights and confidentiality rules regarding trade secrets.
Yes, Article 531B acknowledges that. You have to provide the info, but IP and trade secrets need to be respected.
Providers also have an obligation to share information with downstream providers, Art Pot 531BI.
Correct. They must prepare, maintain, and share enough information to help downstream providers understand the model's capabilities and limitations, integrate it properly into their own AI systems, and comply with their own obligations under the Act. It's about enabling responsible downstream use.
Copyright compliance, Art Pot 531C, is a specific duty for GPAI providers. This sounds contentious.
It is a hot topic. They must implement a policy ensuring compliance with EU copyright and related rights laws. Specifically, they must respect text and data mining opt-outs under the copyright in the Digital Single Market Directive.
Using state-of-the-art technology to do so.
Yes. The handbook references commitments made in the third draft of the GPI Code of Practice related to copyright,
Which we'll discuss next.
like only using lawfully accessible content, not circumventing paywalls or protections, making reasonable efforts to exclude known infringing sites from training data, though reportedly not requiring work-by-work review, prohibiting infringing uses in their acceptable use policy, and setting up a contact mechanism for rights holders.
Transparency information, Art Pot 531D, is also required. Providers must publish transparency info, including
A detailed summary of all material used to train the model. The AI office is expected to provide a template for this summary. This is a significant transparency requirement.
And note that additional transparency obligations from other parts of the Act related to AI systems, Chapter 7 and 11, may also apply if the GPI model is part of or used to build such a system.
Correct. The GPI transparency is separate, but doesn't replace system-level transparency if applicable.
For GPAI providers based outside the EEA, appointing an EEA-based authorized representative, Art.54, is mandatory before placing the model on the market.
Yes, similar to high-risk system providers. The representative verifies the provider's compliance with these Article 53 obligations, maintains documentation for up to 10 years, and cooperates with the AI office and national authorities.
The handbook notes a potential limited open source exemption, ArtPot 542, Rec.111. Providers of open source GPAI models without systemic risk may benefit from an exemption from some compliance and disclosure obligations.
Yes, this is intended to support the open source community and avoid stifling innovation there, while still ensuring full compliance for the highest risk or systemic risk models. The exact scope of the exemption needs careful checking.
The commentary on technical compliance documentation, ArtPut 531A, points out that while Annex XE lists minimum requirements like info on architecture, the exact level of detail needed remains ambiguous.
Right. How detailed does the description of training data curation need to be? That's an area where future guidance or the codes of practice will be really important.
The example of a German company providing a GPAI voice-to-text model, Company X, used by an Italian customer service company, Company Y, illustrates the downstream provider relationship.
Yeah. Company X, the GPI provider, must give company Y, the downstream provider employer, the detailed documentation required under Article 531A, general description, tasks, system types, etc.
And X must balance this sharing requirement with protecting its IP and trade secrets.
Exactly. Providing comprehensive docs helps Y integrate the model correctly and comply with its own obligations, whether as a deployer or if they build their own system incorporating X's model.
Okay, Chapter 14 then focuses specifically on the general obligations of providers of GPAI models with systemic risk. These are layered on top of the general obligations we just discussed.
And they are considerably more stringent, as you'd expect, given the systemic risk label.
The summary emphasizes that these obligations, Art Pass 55 Annex XI, are detailed but not one-size-fits-all. Compliance needs to consider the specific nature of the model and the constantly evolving state of the art in AI safety and evaluation.
Absolutely. What's state-of-the-art today might not be next year.
These additional obligations, Art Pot 551, for systemic risk GPAI providers, require them to take specific measures to identify, assess, prevent, and mitigate risks associated with their models.
This includes providing extended technical documentation, ART Port 543B, referencing Annex S1. Compared to general GPAI models, systemic risk models require more detailed documentation,
Such as,
including, where applicable, a detailed description of the system architecture, explaining how software components are built and integrated. This more detailed info is provided to the AI office and national authorities upon request.
a core requirement is GPO model evaluations, Art Pot 551-5. Providers must perform and document evaluations.
Using standard protocols and tools that reflect the state-of-the-art practices. The handbook gives adversarial testing as an example, deliberately trying to break the model or make it behave badly with unusual inputs to identify and resolve risks from unexpected use.
And the purpose is specifically to test risk levels and identify and mitigate systemic risks.
Yes. Red teaming, vulnerability testing, checking for biases under stress, etc.
Providers must also implement measures for assessing and mitigating systemic risks. Art Pot 551B. This includes addressing risks that arise from the model's use.
Covering reasonably foreseeable misuse or unintended harmful uses.
And specific risks to be addressed include dependencies on single models, potential safety issues, and infringements of fundamental rights.
Correct. A broader assessment of potential societal harms.
Incident documentation and reporting, Art Pot 551C, is another key duty.
Yes. Providers must establish quality management and post-market monitoring systems, similar to high-risk systems, and have reporting obligations for serious incidents, linking to Art Pot 73, adapted for GPAI. They also need to report other information regarding risks identified from their models proactively.
Cybersecurity allegations, Art Pot 551D, are crucial for systemic risk models. Non-EEA providers must implement adequate protection for both the model itself and the physical infrastructure it runs on.
Right. Recital 115 lists examples of risks to safeguard against: accidental model leakage, unauthorized releases, circumvention of security measures, cyber attacks, unauthorized access, and even model theft. Protecting these powerful models is paramount.
The commentary underscores that complying with these obligations for systemic risk models requires a deep understanding of the specific technical characteristics of the model and vigilance regarding the continuously advancing state of the art.
It's a moving target. Compliance requires ongoing effort and investment in safety and security research and implementation.
Okay, Chapter 15 introduces codes of practice specifically for GPAI models. Article 56.
Right. These are designed to help providers navigate those obligations we just discussed.
The summary states these codes are a way for providers to demonstrate compliance with both the general, Art Part .53, and systemic risk, Art .55 obligations.
And crucially, while adherence is voluntary, complying with an approved code provides a presumption of conformity with the relevant obligations.
Until harmonized standards are adopted, so it's a bridge until formal standards exist.
Exactly. The handbook calls them a central tool, Rec. 117, for practical compliance in the interim.
The creation process, Art.561-5, for the first code is underway, involving a multi-stakeholder group.
Yes, providers, civil society, industry, academia. 4 working groups are mirroring the GPAI provisions: transparency, copyright, safety, security, systemic risk, and auditing evaluation.
And the final draft of the first code is expected by August 2025.
That's the target. Then the AI office and AI board will assess its adequacy, and the commission may approve it via implementing acts, giving it general validity across the EEA.
Is there a backup plan if that doesn't happen?
Yes, a significant backstop mechanism, Art. 5649. If the first code isn't finalized or is deemed inadequate by August 2, 2025, the Commission can step in and adopt common rules via implementing acts to cover the relevant obligations itself. So there will be rules one way or another.
The handbook mentions the content of the first code based on the third draft.
Yes, it includes overall commitments covering transparency, copyright, safety, and security, separating general provider obligations for systemic risk ones. There's a detailed transparency section, including a model documentation form based on Annexes 11 and 12 for Article 53(1) compliance.
What's in the form?
Sections covering general info, model properties, distribution licenses, the training process, details on training, testing, validation data, computational resources used, and additional information specifically for systemic risk providers. It aims to standardize that documentation.
What about the future of these codes? Will they be updated?
The handbook notes nothing's announced yet on monitoring or updating, but some stakeholders suggest a permanent task force involving signatories and oversight bodies to review and adapt the codes as technology, society, and the market inevitably change. They can't be static.
The commentary highlights the legal significance under Article 56(7). Although adherence is voluntary, the AI office can invite providers to adhere.
Right. This creates an implicit expectation, doesn't it? Especially for providers who only need to meet the general Article 53 obligations and don't have systemic risk models. Adhering might become the de facto standard.
The commentary also clarifies the relationship between codes and harmonized standards again. Compliance with the code provides a presumption of conformity until harmonized standards are adopted.
If standards are published, it's less clear if code adherence alone still provides that presumption, though codes are expected to be updated to align with any new standards. Art. 568.
And the handbook notes the Act uses the plural codes, suggesting there could be multiple codes covering different aspects or types of GPAI in the future.
Potentially, yes. Maybe specialized codes for different model types or applications.
Okay, Chapter 16 covers measures designed to support innovation. This seems like an important counterbalance to all the regulation.
It is. The summary states the Act includes tools like regulatory sandboxes and real-world testing to help developers test systems before bringing them fully to market. The goal is to encourage innovation, though the handbook notes the ultimate outcome of these measures is uncertain.
Articles 57-63 detail these measures. The aim is to provide support for providers developing and testing AI systems. AI regulatory sandboxes, Art. 1255, sound interesting.
They are. They're controlled frameworks set up by competent member state authorities. They offer a supervised environment for providers to develop, train, validate, and test innovative AI systems, sometimes even in real-world conditions for a limited time, following a specific, agreed sandbox plan.
What are the objectives?
Providing legal certainty, facilitating regulatory learning, sharing best practices, fostering innovation and competitiveness, and accelerating access to the EU market. Art. 557.
Who can participate?
Rules for participation will be in future implementing acts, Art. 581, but the principles include open access based on criteria, broad and equal access, and importantly, free access for SMEs.
The significant benefit of participating in a sandbox is
Providers who adhere strictly to the sandbox plan and rules are not subject to administrative fines under the AI Act, Art. 5712, for activities within the scope of the sandbox.
well, there's a catch.
Yes, the handbook explicitly warns that they may still be liable for damages caused to third parties during sandbox testing. It protects against fines, not civil liability.
How is oversight handled?
The competent authority involves other relevant authorities, like data protection authorities, if personal data is processed. Their normal powers aren't limited by the sandbox. Reporting includes providing proof of activities, detailed exit reports with restricted access, and public abstracts in annual reports.
What about real-world testing? Art. 60, that's testing outside a sandbox.
Yes. This allows high-risk systems to be tested in real-world conditions, but requires specific authorization by the Market Surveillance Authority and registration in the EU database, which we'll cover in Chapter 18.
It offers providers more control over the testing environment compared to a sandbox.
Potentially, yes. But it provides no direct protection against administrative fines under the Act, unlike sandboxes. And the provider remains fully liable for any damage caused during this real-world testing. It's a riskier path from a regulatory perspective.
The handbook notes specific pro-innovation measures for SMEs, Arts. 5862, like free sandbox access, preferential treatment, and support channels to reduce burdens.
Yes, there's a clear effort to support smaller players. It also mentions regulatory sandboxes can exist outside the EU, referencing the UK's approach as an example.
The example used is testing a remote biometric identification system, which is high risk.
Right, testing a prototype. In a sandbox, the advantage could be potentially using personal data collected for other purposes,
Hmm.
if approved in the plan and GDPR, etc. is followed, but you need to apply, be chosen, stick to the plan.
Real-world testing, on the other hand, requires MSA authorization and database registration, gives more control but lacks the fine protection and carries full liability.
Exactly. Different tools for different needs and risk appetites during development.
Okay, Chapter 17 outlines the governance structure established at the EU level to implement the Act. These structures are set to apply from August 2025.
Yes, Chapter 7 details the key bodies responsible for making this all work.
First, the AI Board. That's the European Artificial Intelligence Board, ARTS 2665.
Correct. An advisory body made up of member state representatives focused on facilitating consistent and effective implementation across the EU. Think coordination and advice.
Second, the AI Office, ARTS.34764. This isn't a separate agency.
No, it's a function within the European Commission. It's the central operational body responsible for implementation, monitoring, and supervision of AI systems and GPAI models and overall AI governance.
What will it do?
It will manage the EU database, support sandboxes and real-world testing, issue guidance and assessments. References to the AI Office in the Act are effectively references to the Commission acting in this specific capacity.
Third, the Scientific Panel, ART.68.
Composed of independent experts chosen by the Commission based on expertise and independence. They provide impartial scientific advice to the AI Office.
Like supporting the development of evaluation tools, advising on model classification, alerting the AI Office to potential risks.
Exactly. They're the independent technical experts. Member states can also request their support, potentially for a fee.
In addition to these EU-level bodies, member states must establish or designate national competent authorities, Article 70, by August 2, 2025.
Yes, each country needs its own setup. At a minimum, this includes a notifying authority responsible for managing the conformity assessment bodies we discussed, Chapter 9.
And, crucially, a Market Surveillance Authority, or MSA.
Yes, the MSA is the main enforcement body at the national level. They carry out surveillance activities, check compliance, and have the power to impose fines and other enforcement measures, with specific rules laid down by each member state.
The handbook notes that member states have significant discretion in how they structure these national authorities.
They do. Some are designating new, specific AI authorities, like Spain and Italy have announced. Others are taking a more decentralized approach, assigning MSA roles to existing regulators, perhaps data protection authorities, telecom regulators, consumer protection bodies. Ireland and Finland are mentioned as examples here. Many hadn't finalized their structure when the handbook was written.
The handbook points to specific MSA designations under Article 74, detailed further in Chapter 19, for AI systems used in financial institutions.
The National Financial Supervisory Authority typically acts as the MSA, although a different authority can be designated if there's proper coordination.
And for AI systems used in law enforcement, border management, and justice democracy.
The National Data Protection Authority is designated as the MSA for those specific sensitive areas, Art.748.
And for AI systems used by EU institutions themselves.
The European Data Protection Supervisor, EDPS, acts as the MSA, Art.749.
Finally, member states must also designate authorities for fundamental rights oversight, Art.77, also in Chapter 19.
Yes. Authorities specifically tasked with overseeing the respect for fundamental rights, including non-discrimination, in the use of high-risk AI systems. These authorities have specific powers to request and access relevant documentation.
So, a multi-layered governance structure, both EU-wide and national.
Definitely. Coordination will be key.
Chapter 18 covers the EU database for high-risk AI systems registration. The summary says certain high-risk AI systems must be registered here.
Yes, it's a central repository. The responsibility falls to providers, authorized representatives, or sometimes deployers for specific categories. The database has public and non-public sections, and registration needs to be part of the overall compliance effort.
Articles 49 and 71 and Annex 8.6 cover the specifics. Registration, Art. 49, is mandatory for most high-risk systems listed in Annex 3.
Most. Done by the provider or their authorized representative, or potentially by certain deployers. Substantial modifications to a registered system also require updating the registration.
Is there an exception?
Yes, a key exception. High-risk systems used in critical infrastructure, that's Annex 3, Paragraph 2, are only registered at the national level, not in the central EU database, Art Saga 495, presumably for security reasons,
When does registration need to happen?
before placing the system on the market or putting it into service.
And the required information is specified in Annexes 8 and 9, depending on the system category.
Correct.
The database structure, Art Software CO1, is managed by the Commission. It has a public section.
Containing most of the information, though, interestingly, information about real-world testing is only made public if the provider consents. Art 4714.
And a non-public section.
Yes, containing limited information for sensitive areas like biometrics, law enforcement, and migration AI systems.
And reinforcing that critical infrastructure exception, specific sensitive information listed as Annex 8, Section A, paragraph 689 for these systems is not included in the EU database at all. It's only held nationally.
Correct. That info stays out of the central EU database.
What about personal data in the database?
Limited to what is strictly necessary, primarily names and contact details of the natural persons responsible to registration who have legal authority for the provider or deployer, Art. 715.
The handbook gives two examples. First, a company deploying a high-risk biometric system, Annex 3, Para 1A, for border control management.
Okay.
If they deploy it under their own name, they become the provider, triggering registration. This system falls under Category 1 for the database, requiring Annex 8, Section A info. Because it's biometric border control, it goes into the non-public section.
And specific sensitive details are excluded entirely from the EU database, only held nationally.
Correct.
Second example, an AI system for education admission, Annex 3, Para 3. High risk by category. But maybe the provider considers it low risk in practice and argues an Article 6.3 exclusion applies, meaning it's not high risk for requirements obligations.
But for the database?
It still falls into Category 2, not high risk under 6.2, but subject to transparency, etc. The provider registers it, submitting the less detailed Annex 8 Section B info. And this information goes into the public section of the database.
The practical tip here is important. Coordinate your database registration efforts with your overall compliance program.
Absolutely. It's not just filling out a form. It's a key part of demonstrating conformity and transparency for high-risk or potentially high-risk systems.
Okay, Chapter 19 covers monitoring and oversight. This is about what happens after systems are on the market or in service. How is compliance checked and enforced?
Right. This involves ongoing monitoring and reporting obligations for providers of high-risk systems and specific enforcement powers for national and EU authorities.
Articles 72-78 cover high-risk systems, and 89-94 cover GPAI model enforcement. Let's start with high-risk AI systems. A post-market monitoring system, Art. 72, is mandatory for providers.
Yes, they must establish a system to actively and systematically monitor their high-risk systems once they're on the market. The purpose is to continuously evaluate compliance with those core requirements from Articles 815.
And this needs to be based on a plan available before market placement. Commission guidance expected by Feb 2026.
Correct. On both counts. You need the plan first, then you execute it.
Reporting serious incidents, Art. Pup 73, is another key obligation. What's a serious incident?
It could be anything from a malfunction leading directly or indirectly to death or serious injury, to serious damage to property or the environment, or to serious breach of fundamental rights obligations.
And providers must immediately report these.
Yes, to the Market Surveillance Authority in the member state where the incident occurred, potentially multiple MSAs. Different time limits apply based on the seriousness, but the longest is 15 days from becoming aware.
The example given is a malfunction leading to death requires reporting within 10 days.
Yes. Notified MSAs then inform other relevant national authorities, who notify the Commission if the incident is deemed serious. High-risk medical devices subject to equivalent reporting under MDR-VDR must also fulfill those requirements. Commission guidance on this reporting is expected by August 2025.
Enforcement and market surveillance is carried out by the MSAs, Art. 74, which member states must designate by August 2025.
As we discussed in Chapter 17, these are the main national enforcement bodies. Remember the sector-specific MSAs to Financial Supervisors for Finance AI, DPAs for Law Enforcement Border Justice AI, and the EDPS for EU institutions.
MSAs have powers to demand corrective measures, Art. 79, if systems pose a risk or are non-compliant, including withdrawal or recall.
Yes, they have a range of enforcement tools.
Fundamental rights oversight, Art. 77, is handled by designated national authorities who oversee respect for fundamental rights in high-risk AI use, with powers to request and access relevant documentation.
Correct. A specific focus on fundamental rights impacts.
And confidentiality, Art. 78, is required for all involved authorities, protecting trade secrets and personal data, but balanced with transparency needs.
Yes, standard confidentiality duties apply, but they can be overridden if disclosure is necessary for public interest, health, safety, or protecting fundamental rights.
Now, for GPAI models monitoring and oversight,
The AI office has broad monitoring power here, Art. 89, and downstream providers can use a complaint mechanism, Art. 892, to report non-compliant GPAI models they might be using or integrating.
the scientific panel can also issue alerts, Art. 90, to the AI office if they suspect a concrete risk or if a model meets systemic risk conditions.
Yes, acting as that expert watchdog again.
Based on these alerts, the Commission can take actions, Art. 902, after informing the AI board using its powers to assess the situation.
Correct.
And these Commission powers, Arts. 9193, include requesting documents, conducting evaluations, potentially requiring access to the models, and requesting providers take specific measures.
Yes. Measures like bringing the model into compliance, reducing risks, or even, if necessary and appropriate, limiting the model's availability or withdrawing it from the market. Art. 93.
They have real teeth.
Procedural rights, Art. 94, apply during these investigations, ensuring fairness for the providers.
Yes, mirroring the market surveillance regulation, clear legal basis, prompt communication, information on remedies, and adequate time to respond. Minimum 10 working days unless urgent.
Okay, Chapter 20 introduces voluntary codes of conduct and guidelines. This is separate from the GPAI codes.
Yes.
The summary highlights that, separate from mandatory rules, there are encouraged voluntary codes of conduct for non-high-risk AI systems. Plus, the Commission will issue broader guidelines to help implement the Act.
Articles 95 and 96 cover this. Voluntary codes of conduct, Art. 95, are encouraged for providers and deployers of non-high-risk AI systems. Why?
The aim is to foster voluntary compliance with certain requirements from the Act. Things like implementing risk management systems or adhering to transparency principles, even where those requirements aren't strictly mandatory for that specific lower risk system type. It's about promoting best practices across the board.
The handbook notes these are distinct from the transparency codes under Article 57 and the mandatory GPAI codes under Article 56.
Correct. These are purely voluntary industry initiatives. Their drafting process will be facilitated by the AI office and member states, but for these codes, the providers, deployers, and industry organizations involved hold the pen.
Separately, guidelines on implementation, Art. Sun 6, are something the Commission is required to create.
Yes, the scope is broad. The Commission can develop guidelines on any aspect of the Act's practical implementation where clarification is needed.
Specific topics emphasized for these guidelines include how to implement the high-risk system requirements, how to interpret and avoid prohibited practices, ensuring consistent enforcement alongside other EU laws.
And importantly, providing guidance on that challenging definition of an AI system, Art. 3.1. The handbook notes guidelines on the definition were actually already issued in February 2025.
These guidelines sound like they will be crucial resources for everyone trying to navigate the Act.
Absolutely. They should provide much-needed practical direction and clarification.
Chapter 21 explains delegated acts. This sounds like a technical mechanism, but important for keeping the Act relevant.
Very important. The summary says this allows the Commission to adopt non-legislative acts to update specific, detailed, technical parts of the law relatively quickly, under the oversight of the European Parliament and Council. It's about future-proofing.
Articles 97 and 98 detail this. The purpose is to make the legislation agile enough to respond to dynamic technical progress in AI.
Exactly. Addressing detailed technical aspects without needing to go through the full, slow legislative process to change the core law every time technology evolves.
Under Article 97, the EP and Council delegate power to the Commission to adopt these non-legislative acts, which can supplement or amend certain non-essential elements of the Act.
Correct. Non-essential is key. They can't change the fundamental principles, only specific technical details listed in the Act.
And there are crucial oversight mechanisms.
Yes, the initial delegation is for 5 years, from August 2024, tacitly extended unless EP or Council object. They can also revoke the delegation anytime. The Commission must consult member state experts before adopting an act and notify the EP and Council simultaneously. They have 3 months to object.
Plus, there's a committee procedure, Art. 8.
Yes, the Commission is assisted by a special committee of member states. The Commission needs a qualified majority vote in favor from this committee to adopt an act, providing direct oversight by the member states.
So what are the specific areas listed where the Commission can use delegated acts?
The handbook lists several key ones. Updating the high-risk criteria and use cases by amending the Annex 3 list, Art. 667-713. Keeping the technical documentation requirements in Annex 3 up to date, Art. 11.3, amending or updating the conformity assessment procedures in Annexes 8, and potentially expanding the scope of Annex 7 based on risk assessment, Art. 4356.
Also updating the EU Declaration of Conformity info in Annex V, Art. 475, and crucially for GPA.
Updating the criteria for GPAI systemic risk classification in Annex 13, including that fourth 125 FLOP's computational threshold, which will almost certainly need regular revision, Arts. 513.533.
And finally, delegated acts can be used to clarify how to measure or calculate compliance with certain GPII tech doc requirements in Annex 11, Art. 5356.
Correct. It's focused on keeping those technical annexes and thresholds current.
The commentary notes this mechanism is common in EU law for dynamic areas like digital services, DSA, data protection, GDPR, and product safety, GPSR.
Yes, it's a standard tool to balance the need for stable core legislation with the ability to adapt technical details relatively swiftly, while ensuring the democratically elected bodies, EP and Council, retain ultimate control through objection or revocation powers.
Okay, Chapter 22 gets straight to the point. Penalties. The consequences of getting it wrong.
And they can be severe.
The summary highlights substantial maximum fines up to 35 million or 7% of worldwide annual turnover. Member states set their national rules, but they must be effective, proportionate, and dissuasive, with specific consideration for SMEs.
And there are different maximums for different types of breaches. Crucially, the worldwide turnover basis means fines can apply even if a business has no physical presence in the EEA, as long as they fall into the Act's scope.
Articles 80, 91, 92, and 99, 101 lay out this framework. Member states are responsible for defining their national rules for penalties, Art. 99, which must be effective, proportionate, and dissuasive.
And remember that specific mandate. National rules must take into account the interest and economic viability of SMEs, including startups. That's an important protection.
The Act sets specific maximum fine limits, Art. 99, based on the type of breach, the highest tier.
Up to 35 million or 7% of worldwide annual turnover, whichever is higher. This applies to breaches of the prohibited AI practices under Article 5, Chapter 5. The most serious offenses get the biggest potential fines.
A medium tier.
Up to 15 million or 3% of worldwide turnover. This applies to breaches of most other obligations for operators, providers, importers, distributors, deployers, or notified bodies, other than the Article 5 prohibitions.
So this covers things like non-compliance with the high-risk requirements, Arts. 16, 21, 24, 26 from Chapter 8, notified body obligations, Arts. 31, 34 from Chapter 9, and transparency obligations, Art. 50 from Chapter 11.
Exactly. Still very significant penalties.
And the lowest tier.
Into 7.5 million or 1% of worldwide turnover. This is for providing incorrect, incomplete, or misleading information to a regulator.
Crucially for SMEs, the maximum fine is set as the lower of the percentage or the specific euro amount specified for each tier.
Correct. That provides some cap for smaller businesses where the percentage might otherwise be cripplingly high relative to the fixed amount.
EU institutions can also face penalties, Art. 100, fined by the EDPS.
Yes, for data protection and privacy breaches under the Act related to their own use of AI.
And for GPAI providers, the Commission is empowered to impose direct fines, Art. 101, not relying on national authorities.
Correct. This can be up to 3% of annual worldwide turnover, or 15 million, whichever is higher, for intentional or negligent infringement of the specific GPI provisions, or failure to comply with Commission requests for information, measures, or access for evaluation under Articles 91-93.
The commentary highlights the significance of the worldwide turnover calculation basis, consistent with other EU digital laws like GDPR, DSA, and DMA.
Yeah, it means large global companies aren't shielded by having only a small physical presence or low revenue within the EEA. The fine is based on the entire global economic unit's turnover, preventing corporate structuring games to minimize exposure. The high maximums, 175% of the GDPR max, are clearly intended as a very strong deterrent.
The commentary also notes the specific mention of SMEs and startups, and the lower maximums for them reflects a deliberate EU attempt to balance robust enforcement with protecting smaller businesses.
Yes, trying to avoid sanctions that could stifle innovation or put SMEs out of business unfairly.
Regarding the speed of large penalties, the commentary reiterates that immediate maximum fines are unlikely for most businesses right away.
Seems probable. Due to the inherent complexity, the need for regulatory infrastructure, MSA's AI office, to be fully operational, and the staggered rollout of enforcement itself. Regulators need time to develop guidance, processes, coordination.
They may also be hesitant to issue huge fines based on unclear interpretations given the risk of appeal, though some national authorities might be more aggressive.
That's the calculation they'll have to make. But the staggered enforcement timeline we're about to discuss is also a key factor in how quickly penalties might actually be applied in practice.
Okay, that brings us directly to the final operational chapter, Chapter 23, commencement and timing. This is absolutely critical for understanding when different obligations under the Act actually become enforceable.
It really is, and the summary correctly identifies this as a complex, staggered timeline. Different provisions apply from different dates, and there are varying grace periods for different system types. It's not a single go-live date.
Articles 111, 112, and 113 detail this. While the Act formally entered into force on August 1st, 2024, 20 days after publication, enforcement doesn't begin for everything at once.
Right, the staggered application dates are the key points businesses need to track carefully. First up, February 2, 2025, 6 months after entry. Rules on the basics like subject matter scope, definitions, AI literacy, and crucially, the prohibited AI practices, Art Point 5, begin to apply. Also, provisions on notifications, certain GPAI enforcement issues, and the penalties framework itself.
So the absolute bans kick in relatively quickly.
Yes, February 2025.
Yes.
August 2, 2025, 12 months after entry. Certain rules, specifically regarding GPI models, likely governance and monitoring aspects, come into effect. And importantly, the governance structure provisions, Chapter 17, setting up the AI Office and national authorities, also apply from this date.
So the regulators officially come online then.
That's the plan. Then a big one, August 2, 2026, 24 months after entry. This is when the bulk of the operative provisions apply. It also marks the end of the general grace period for most high-risk AI systems classified under Article 6. Those requirements apply to our high-risk, high-risk systems placed on the market or significantly changed on or after this date.
So a 2-year runway for most high-risk compliance.
Generally, yes.
Okay.
Then, August 2, 2027, 36 months after entry, rules concerning high-risk AI systems classified under Article 6.1, those as safety components of products under other EU law, come into effect. The grace period for high-risk systems specifically intended for use by public authorities also ends then.
And enforcement starts for older GPI models.
Yes, enforcement starts for GPAI models that were placed on the market before August 2, 2025. They get that 2-year grace period we mentioned. And finally, way out, December 31st, 2030. A specific grace period ends for certain AI systems that are part of large-scale IT systems covered by Annex X, provided they were placed on the market before August 2, 2027.
Okay, this distinction based on the placement date is highly significant for GPAI models.
If you placed your model on the market before August 2, 2025, you effectively have that 2-year reprieve from enforcement of GPAI obligations until August 2, 2027. If you place it on the market on or after August 2, 2025, those GPAI obligations face immediate enforcement risk from that date.
Creates a clear incentive for early market placement of GPI models.
Absolutely. Get it out before August 2025 if you can.
Similarly, for high-risk AI systems under Article 6.2.
If they were placed on the market before August 2, 2026, they're generally not subject to enforcement of the high-risk requirements unless they undergo significant changes later.
Again, incentivizing early placement and, if placed early, avoiding substantial modifications after the deadline. The handbook points out Recital 177 confusingly equates significant change with substantial modification.
Yeah, the terminology could be clearer, but the principle is major changes after the deadline trigger compliance for older systems.
The Act also mandates ongoing evaluation and review, Art. 112, by the Commission.
Yes. Annually, starting August 2024, they must review the need to amend the Annex 3 high-risk list and the Article 5 prohibited practices list. Every 4 years, starting by August 2028, broader evaluations of the Act's impact, supervision, governance, etc., with potential amendments proposed based on tech or societal changes.
The commentary on the timing for high-risk systems already on the market acknowledges the staggered timeline gives businesses time, but clearly creates incentives for early market placement.
Definitely. For GPAI before August 2025, and for high-risk systems before August 2026 if no significant changes later.
A final point raised in the commentary regarding timing. What if an enforcement deadline passes, but regulators aren't fully ready?
The handbook clarifies that the legal obligation to comply still exists from the specified date. compliance isn't automatically suspended, while a lack of a functioning MSA might potentially be a mitigating factor in a later enforcement action if a business acted in good faith. Recital 178 encourages voluntary early compliance.
Businesses should not assume they are safe from future actions simply because enforcement capacity is delayed.
Correct. The obligation is live on the deadline date, regardless of the regulator's readiness.
Okay, that brings us to the final chapter covered in this handbook, Chapter 24, the overlap between the EU AI Act and other relevant laws and guidelines. This seems crucial.
It really is. The summary is blunt. The AI Act doesn't exist in a vacuum. Many other EU laws impact AI data protection, digital services, product safety, etc. The Act generally works in concert with these laws, but understanding the points of overlap is absolutely essential.
Yes, the handbook lists several key areas of overlap, noting the list isn't exhaustive. Given how pervasive AI is, interacting with multiple legal frameworks is just the reality now.
First up, the big ones. GDPR and the e-privacy directive, covering data protection. As we touched on earlier, the overlap is significant when AI systems process personal data.
The Act is without prejudice to GDPR, but this creates potential for parallel liability.
Yes, the handbook starkly illustrates this again. A data breach involving AI could potentially lead to liability under both GDPR and the AI Act, with potentially very high aggregate fines and separate damages claims. You have to comply with both fully.
The DSA Digital Services Act and DMA Digital Markets Act, regulating online platforms and gatekeepers.
They overlap where these platforms use AI for things like content recommendation, moderation, or personalized advertising. DSA DMO focus more on competition and platform behavior, while the AI Act focuses on the technical aspects of the AI deployment.
But companies subject to DSA DMO will very likely also need to ensure their AI systems comply with the AI Act.
Almost certainly. Both sets of laws impose obligations aimed at ensuring fair, rights-compliant, and safe use of AI in the platform context.
The machinery regulation applies generally from January 2027.
Sets health and safety requirements for machinery. If machinery incorporates AI, manufacturers are subject to both laws. They need to meet both the Machinery Reg safety standards and the AI Act risk management transparency requirements. Conformity assessments might need to cover both.
MDR, medical devices regulation, and IVDR, in vitro diagnostics regulation.
Huge overlap here, as we've seen. AI-powered medical devices, or IVDs, often fall under the definition of high-risk AI systems, especially if they require third-party assessment under MDR-IVDR. Both laws require a QMS. MDR requires post-market surveillance. The AI Act complements this with specific requirements for continuous AI system performance monitoring and incident reporting. Manufacturers need to comply fully with both.
The handbook mentions the proposed AI Liability Directive, AIL, but makes a crucial note.
It was withdrawn by the Commission in February 2025. Lack of foreseeable agreement. So that specific proposal is off the table for now. The Commission is assessing what to do next about AI liability rules.
However, the revised Product Liability Directive, RPLD, is very much active.
Yes. Entered into force December 2024, transposition by December 2026. This modernizes the old 1985 PLD and is highly relevant to AI.
How so?
It explicitly considers software and AI, whether standalone or embedded, as products. It introduces strict, no-fault liability for a broader range of damage, including psychological harm, data loss. Liability can extend post-sale for issues from updates, cybersecurity, or machine learning drift. It eases the burden of proof for claimants in complex cases and requires manufacturers to share info. More supply chain actors potentially liable too.
The handbook notes some ambiguity may remain regarding what constitutes a defective AI system under this revised framework.
Yes, that will likely be tested in courts.
The revised Child Sexual Abuse Directive, RCSAD, is another proposed law still in procedure.
Yes, last updated Recent 24. It enhances criminal law against child sexual abuse. Key AI amendments revise the definition of child sexual abuse material, CSAM, to explicitly include AI-generated content like deepfakes. It also increases the scope of offenses committed via information and communication technology, which may include AI.
Stakeholders suggest clarification is needed on AI-generated images in the CSAM definition. Businesses using AI capable of creating CSAM need careful consideration here.
Absolutely, a very sensitive area where AI Act obligations and criminal law intersect.
Finally, the handbook references the EDPS orientations for generative AI and data protection, June 2024.
This provides non-binding guidance specifically for EU institutions on lawfully processing personal data with generative AI under their specific data protection rules. Regulation EU 2018-17-25, while not directly binding on businesses.
It offers helpful analysis on data protection issues related to generative AI that can be informative for everyone.
Exactly. It shows the thinking of a key EU regulator on these issues.
The concluding thought on these overlaps from the handbook is clear. The interplay is indeed
It
complex.
really is. Requires navigating multiple legal frameworks simultaneously. Compliance under one law doesn't automatically guarantee compliance under the others. You need a holistic view.
And that brings us to the end of our journey through this EU AI Act handbook. Phew, that was a lot.
It certainly was. It's a dense piece of legislation, and the handbook reflects that while trying to make it navigable.
We've walked through its pragmatic structure, from setting the stage and grappling with core definitions and scope, through the outright prohibitions, the detailed requirements, and layered obligations for high-risk systems.
The specific rules for GPAI models, including those stringent duties for systemic risk models.
The supporting infrastructure of notified bodies and governance, the process of conformity assessment, standards, and registration.
The crucial staggered timing of enforcement. And finally, that complex web of overlaps with other critical EU laws.
The handbook and our exploration of it really drives home the complexity, the acknowledged uncertainties, and the dynamic nature of AI regulation in the EU. It highlights that this is a challenging landscape for any business involved with AI.
No doubt about it.
But it also provides that essential pragmatic map we discussed at the start. It helps you pinpoint the key areas you need to focus on right now.
Yeah, it's honest about where clarity is still needed, but it offers insights drawn from experience navigating similar legal complexities, like GDPR.
It gives businesses practical direction on building their compliance foundation today, emphasizing that progress over waiting for perfect certainty.
Which seems like the only realistic approach, really.
And as we wrap up this deep dive, it leaves us with a fundamental question to ponder, doesn't it?
I think so. The Act's stated goal is ambitious, ensuring AI is trustworthy, safe, and respects fundamental rights across the EU.
But given the breakneck speed of technological advancement, the inherent ambiguity in some of its core definitions, the intricate way it intersects with other existing laws, and that multi-year phased approach to enforcement.
How will the real-world implementation and the inevitable future interpretations by courts and regulators truly manage to strike that delicate balance? The balance between fostering vital innovation and providing the robust protection that the law intends.
That's the billion-euro question, isn't it? This deep dive has hopefully given you, the listener, the map and the key insights from this handbook to begin grappling with that very large and unfolding question.
We hope it's been a valuable use of your time navigating this complex but crucial topic.